Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to be discussing a case that I briefly mentioned in a short about a month ago. You might recall seeing this order from the Supreme Court of Georgia, and the order is a per curiam order, and it's in a basically a discipline case for an attorney. And the gestalt of the complaint was that the young lady at issue, Marsha Mignott, had violated some bar rules. But when the Supreme Court started looking at it, they said, we conclude that Mignott did not violate either Rule 1.8 or 1.9 because, as the bar stipulated, Mignott never formed an attorney-client relationship with the grievant, and the provisions of the rules with which Mignott was charged don't apply to prospective clients. Now, if you read that, what you might think is, wow, somebody did something bad, and because the rules weren't just right, well, she escaped with a technicality. But that's not it. In fact, this opinion does not tell the whole story. Let me see if I can put this in a way that makes sense. This opinion is like saying that World War II against Japan was a minor dust-up between two nations over the rights to certain islands in the Pacific. Now, that's completely true, right? But it does sort of leave a lot out, and it's the part of the story that is left out, things like the Bataan Death March and the Battle of Midway, that really lend some context to World War II against Japan. And in this case, what's missing here is the timeline and what Paul Harvey would call the rest of the story. So let's take a look at the timeline and see if we can figure out what it is I mean here. Before we go there, I need to sort of tell you who the players are. First is Marsha Mignott, an attorney in Fulton County, Atlanta, the Atlanta area, who practices, among other things, immigration law. And her client in this matter was a gentleman by the name of Mr. Sinclair, and the woman who would later become his wife and the subject of the real issues in this case, Doreen Mitchell, was basically somebody who sat in on a client interview at one point. So to make the whole case make sense, let's take a look at the timeline. On September 9th, 2016, Mr. Sinclair comes into the office and Ms. Mitchell is with him. She doesn't say a word, she just sits there. And Mr. Mitchell talks with Marsha about this particular immigration matter, whether or not to pursue it, how much it's going to cost. And she gives him some documents that basically give him a quotation for how much this is going to be. Well, sometime between September 9th, 2016 and March 15th, 2018, Sinclair marries Doreen Mitchell, one of the women who was there in the office with him, and has a child with her. On March 15th, 2018, Sinclair comes back to her office for a second consultation, this time complaining about domestic abuse and the fact that the woman that he married now is no longer lawfully in the United States and is threatening to take their child to a foreign country. So Mr. Sinclair files for divorce, and this temporary protection order is filed, which would prevent the child from being taken out of the United States, among other things. And Mitchell's lawyer appears at a hearing on that motion on the 30th, a couple of days after the divorce was filed. And at that hearing, she presents a forged document that claims to establish an attorney-client privilege and an attorney-client relationship with Ms. Mignott. This is, in fact, a rather cheap way of trying to get Ms. Mignott thrown off the case. And her lawyer says, you've got a conflict of interest, you have to let this client go. But she contacts the Georgia Bar Council on that same day, and the Georgia Bar Ethics Council says, no, there's no conflict of interest here. So she continues representing Mr. Sinclair. And then on the 14th of September, 2018, she deposes Ms. Mitchell in the divorce. She admits that she did not consult Mignott. She admits she did not hire Mignott, and essentially admits that she didn't have an attorney-client relationship at any point with Ms. Mignott. Shortly after that deposition was taken, on December 18th, 2018, Ms. Mitchell filed a bar complaint with a forged document. When Mr. Sinclair came in September of 2016, he got a note and a receipt, basically, on his client form that showed how much he would have to pay if he retained her services to represent him in this immigration case. Ms. Mitchell had altered that document to make it look like she was the client and Mr. Sinclair was not the client. She filed the bar complaint and attached that forged document. Well, that certainly had the effect of really irritating the heck out of Ms. Mignott, because there clearly should not be a complaint filed with a forged document. And she brings this to the bar's attention, by the way. In the interim, in March of 2019, a judge issues a warrant for first-degree felony forgery, and then let me see if I can figure out exactly, September of 2019, a Fulton County grand jury returns an indictment against Ms. Mitchell. Well, given the fact that you have a forged document, you would expect at this point that the state bar would look at this and say, okay, there's no there. But that's not what happened. And what happened is really something of a travesty. Now, you may be wondering just exactly what evidence there is of forgery. And so Ms. Mignott went to a hearing with an application for a warrant to get her arrested, Ms. Mitchell arrested for forgery. And she presented all of the evidence. Ms. Mitchell was represented by counsel at this hearing. And here are the judge's findings. I do find that this particular document has been altered, and the alteration is when Ms. Mitchell writes that this was given as a receipt for services paid. There's been absolutely no evidence whatsoever that she ever paid a dime. Mr. Sinclair and his attorney, Ms. Mignott, testified in fact and presented evidence to the court that this was a consultation. No money was paid by her. She sat there and never said a word. This is a list of documents needed in the future if, in fact, Ms. Mignott is hired. What happened was, and I find this highly suspicious, that what comes to us, Ms. Siegel, later on is ripped up in such a way that the sign-in sticker is missing. She's given literally the bottom half of this page and the top of this page, and not the sign-in sheet, not the date, not the timing, and Mr. Sinclair was, in fact, the one who signed in and put his signature all over this paper. In other words, not Ms. Mitchell. So what we have is pieces of documents submitted to the state bar with an additional writing on it, which, as the statute requires, purports to have a different provision than what's being stated. That money was paid to her by Ms. Mitchell and to represent her, and the testimony is, in fact, quite the opposite of that. So I do find that there is enough evidence presented by the plaintiff. Y'all know this is not a criminal trial. There's a much lower standard of proof required at a warrant hearing, but based on Attorney Mignott's presented to me, and I will, in fact, issue a warrant for the offense of forgery. And this is a copy of the actual indictment in Fulton Superior Court, State of Georgia versus Doreen Mitchell, filed September 6, 2019, and it has all of the information. The grand jurors signed that Doreen Mitchell is charged with the forgery in the first degree under the Code of Georgia, and they cite the statute section on the 18th day of December 2018, did unlawfully and knowingly alter a writing. So obviously it's signed by the district attorney and it's on file in the Fulton County Court. The evidence is fairly clear, and there is a long trail of documents here that establishes that Ms. Mignott was actually the victim in this case and was not somebody who was practicing unethically. Even though, if you read the opinion, you come away with the impression that that, first of all, the state disciplinary authority, and then second of all, the hearing panel that was brought in to hear the case were absolutely convinced that this woman violated all these rules, when in fact, if they'd read the rules, they would know those rules did not apply. It is amazing to me that they used a fly-on-the-wall standard to determine whether or not she was a client. And I want to make something clear here. There is a lot more evidence here. There is stuff that, really nails this down. There are so many errors, I think, administratively and evidentiary inside the hearing panel that conducted the hearing against Ms. Mignott that I'm just at a loss to try and explain it. But I'm shortening this down so that I can keep it a reasonable length. If you have any questions about it, there's my email. Feel free to ask. If somebody comes to a lawyer and says, I want to hire you to represent me, a couple of things happen. First of all, we ask for a little information. What do you want to be represented on? What happened? What kind of case is it? Because somebody might say to a civil attorney, well, I got arrested for fraud. And at that point, we'd say, time out. We don't do criminal work. I don't want to hear any more. I can give you the names of several good criminal defense attorneys. But in other cases, perhaps in a criminal case, you might want to hear all of the facts before you decide whether or not you can help someone. And in that situation, you do get confidential information. But confidential information is different from information. And the Supreme Court of Georgia, I think, kind of played fast and loose here, and I'll show you what I mean. The court opinion says Mignott was accused of learning information from a prospective client. And of course, that's natural. That's normal. You learn information. Name, address, telephone number, email address, work address. What do you do? What is it you want to have representation on? Those are all information, but they're not client confidential information. And they're not the kind of thing that is going to trigger essentially going to trigger some kind of conflict of interest. Rather, what will trigger a conflict of interest is the sharing of confidential information, client confidences. I wrote a bad check. Yes, I defrauded my bank. Yes, I broke the contract. Those are the kind of confidences that could potentially harm somebody. And as long as you've formed a valid attorney-client relationship, meaning that you've approached the lawyer, asked to hire him, and the lawyer has agreed to be hired, and you've signed a contract, then in most cases, there is a confidential relationship. And even if confidential information hasn't been shared in that setting, it's probably a good idea to consider there to be a conflict, even if they haven't shared much more than their name and phone number. But where somebody comes into the office and sits down and you explain to their partner that in order to be hired, you're going to need this much for a retainer, and you'll set up a payment plan with them, and if they can make the payment plan, you'll be happy to represent them. That's quite different. That person sitting there as sort of the fly on the wall doesn't have any expectation that you are representing her. And that's the situation that presented itself to the Georgia bar. And what's really odd about this is Mignott called the Georgia bar, disclosed the relationship, and said, do I have a conflict? Do I need to withdraw? And Georgia Bar's counsel said, no, you don't. There's no conflict here. Now, there's a saying that all's well that ends well, but that's nonsense in this case. Ms. Mignott had to hire counsel. She wound up paying a hefty premium on her professional liability insurance because she's charged with unethical conduct, and insurers are apt to believe that somebody charged is guilty, and they raise the rates accordingly. She has suffered damages as a result of this. Now, Ms. Mignott believes that because she is an African-American woman, that the bar is actually biased against her for reasons of her skin color and heritage. And I hope that that's not the case. I really do. I will leave that issue to another day because Ms. Mignott has filed a federal lawsuit against the disciplinary authority and the State Bar of Georgia. And that's going to be heard in federal court. And if it's certified as a class action, as she hopes that it will be, it may indeed cause some changes or some shakeup in how the disciplinary process is operated in the state of Georgia. I think Ms. Mignott did everything right. She did everything I would have done in that situation. And I can't believe that the Georgia Bar proceeded with this. I can't believe that the disciplinary authority thought that there should be discipline when the whole issue of an attorney-client relationship was fabricated. There was no prospective client there. She wasn't there as a prospective client. So that's what I have for you today. Hopefully you found this interesting, useful, helpful. At the very least, I hope that it sets the record straight for Ms. Mignott. She didn't do anything wrong, and it is unfair for her to be tarred with that brush. I hope that today I am able to do a kindness for Ms. Mignott. As you know, it's important for me here to try and urge people to do kind things for other people. What the Georgia Disciplinary Authority did was very unkind, and I hope that they have the ability at some point in time to admit their mistake and apologize for it. That would be the honorable thing for them to do. Thank you so much for watching. If you have a question about this, that's my email. And of course, go out and do something nice for somebody today, and then catch me down here at the beach again tomorrow. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.